So Jeff, we wanted to revisit this McDonald's Corp versus Austin Mutual decision. There's certain specific and certain significant implications for both the franchise practice group as well as the hospitality group. Why don't you give us a bit of a background there in terms of that decision?
Sure, Rich. This is an important decision because it takes COVID-19 into the liability realm. Previously, we've spent a lot of time evaluating business interruption coverage, first-party coverage for COVID-19 losses. This is the first reported liability case talking about potential coverage, liability coverage for COVID-19. So the facts are several McDonald's employees, along with their immediate family members, brought a claim against two McDonald's franchisors in Illinois. The causes of action were public nuisance and negligence, but interestingly, the plaintiffs sought an injunction to enjoin McDonald's from certain behavior related to COVID-19. So for example, they alleged that McDonald's was not keeping their customers socially distant. They were not providing PPE to their employees. They were requiring their employees to reuse dirty masks and things of that nature. So the plaintiffs sought an injunction against McDonald's for that conduct. They did not seek monetary damages. McDonald's, in turn, took the lawsuit and turned it over to Austin Mutual, their liability insurer, demanding a defense. The liability insurer denied coverage on several bases, which we're going to examine in a moment. But the holding was that the court determined that Austin Mutual owed McDonald's a defense for these claims. So, Rich, why don't we just unpack a couple of the issues that led to that holding?
So a few points that I want to emphasize, and you'll see why. First and foremost, we had a number of underlying plaintiffs that did in fact test positive for COVID-19, as well as their family members. So we had a showing of bodily injury there that the court found in this latest action here. Damages, with respect to damages, a large question that was before the court was whether or not the mandatory injunction that was being sought and the claims that were actually being asserted against McDonald's corporate as well as these franchisees constituted damages that would in fact be covered under a general liability policy. The court, Northern District of Illinois, again, they found that they did in fact constitute covered damages under a general liability policy. The last issue is causation here, and not to be forgotten, the language that's in the insuring agreement of a general liability policy covers damages because of either bodily injury or property damage. So that because of, the court construed that broadly here, and the court said that because of does not require a showing of proximate cause, but more but for causation. So that was again favorable and a necessary component in a finding of coverage here. So three main points there. Why don't we talk about some more big picture takeaways here that policyholders should keep in mind? Sure,
Rich. And you hit on one, which is it's very important, this expansive interpretation of because of bodily injury. We often see, so for example, in the liability policy, it covers damages because of bodily injury or property damage. And we've seen, and we've talked before about damages because of property damage. Here we have an expansive interpretation of because of in the bodily injury context. That's a key takeaway. The second key takeaway would be that the court determined that exposure to a harmful contaminant can constitute bodily injury even without manifestation of the sickness. So even for those plaintiffs that didn't contract COVID-19, the court still determined that there was bodily injury sufficient to trigger coverage. And then the third takeaway that I think that it's not a key part of the holding, but it's something for our clients to keep in mind is in the liability policy, Part C actually covers medical payments related to bodily injury caused by an occurrence on premises you own. And that coverage can be important in a situation like this because it can cover necessary first aid, x-rays, ambulance service, and even some certain hospital services. So it's important for our clients to keep that little piece, that Part C piece, which rarely comes into play, to keep that in mind in a situation like this. Great point. I don't know how in-depth the court got into those issues there, but that's a great point to bring up. Last 2 points I wanted to raise: communicable disease exclusion and other virus or relevant exclusions that would be applicable to COVID-19 related liability claims.
Be aware of whether or not they are on your policies, and to the extent that your carriers attempt to add them on at the time of renewal. It's very important going forward. And lastly, wanted to bring it full circle here. We're starting to see these claims pop up a bit more frequently as we're seeing states and the country in general open up a bit further. So be aware of these issues and where you stand in terms of coverage under your general liability policies. Tune in next time. We're going to be having a further discussion on some of the related issues of workers' comp coverage and COVID-19. Thank you.
Thank you very much.